जजमेंट ओपनिंग डे, हाँ उसको एक ऑर्डर ड्रॉ करना है, जजमेंट वाला पोस्ट ऑन ओपनिंग डे 11.
From supplementary list for admission item 6, WPC 585 of 2019.
Who's for the petitioner? WPC number 585 of 2019. Nobody appears for the petitioner. Counter affidavit on behalf of respondent number 5 has been filed. Holds this case on opening Tuesday. The rejoinder to the counter affidavit, if any, be filed by 11th of November. Give your reference. Next.
Okay,
Item 7, WPL 2743 of 2019, along with item 8 and 9.
इसका ना फाउंडेशन वर्क किया हुआ मेरे पेन ड्राइव में, कॉन्फ्रेंट की शायद, आई डोंट रिमेंबर हु वाज दैट. After hearing the learned counsel for the parties, upon perusal of the agreed award dated 30/10/2018, this court finds that essentially the matter related to non-payment of wages for 13 days in the last month of the service of the applicant, and consequently a petition under section 33C with the bracket 2 of Industrial Disputes Act 1947 was filed. The specific case of the petitioner before the learned court was that the amount was already paid by way of advance, but at the time of giving the salary for the last month, it was deducted. The learned court framed two issues in para 7, which are as under. The sole argument of the petitioner before this court is that the petition under section 33C (2) of the Act of 1947 was itself not maintainable. So largely the argument on the ground that there was a dispute with regard to the entitlement of the amount. The issue was decided by the learned court, White, paragraph 8, which is quoted as under. The learned court was of the view that it was not a case of determination of wages or entitlement of the applicant. Rather, it was a matter of interpretation that the wages have been deducted or not. This court also finds that the entitlement of 13 days wages was not in dispute. What was in dispute was whether the same was already paid to the concerned workman in advance. In the judgment passed by this court in LP number 379 of 2012, which has been relied upon by the learned counsel for the petitioner, it has been held in paragraph 25 by referring to the judgment of the Honorable Supreme Court reported in bracket 2005, bracket news 8 SCC 58. It has been observed that in a proceeding under section 33(c)(2), the Labour Court has no jurisdiction to first decide the workman's entitlement and then proceed to compute the benefit so as to adjudicate on the basis of its power under section 33(c)(2). It has been held therein that it is only when the entitlement has been earlier adjudicated or recognized by the employer, and thereafter for the purpose of implementation or enforcement thereof, some ambiguity requires interpretation, that the interpretation is treated as incidental to the Labour Court's power under section 33(c)(2), like that of the executing court's power to interpret the decree for the purposes of its execution. This court finds that the entitlement to receive wages was not in dispute. What was in dispute was whether it was already paid or not, and whether it was paid by way of advance as claimed by the petitioner. Under the aforesaid circumstances, when the entitlement of the workman was not in dispute, this court is of the considered view that the learned court rightly held that the petition under section 33(c)(2) was maintainable. This court also finds that while deciding the case, the learned court also observed that no order or circular or previous payslip was brought on record by the petitioner to prove that the management was paying advance wages of 13 days. Nor any attendance register to the learned court, after considering the materials, recorded that deduction of 13 days wages of the applicant by the petitioner was unwarranted and unjustified, and therefore the claim was genuine and bona fide. Paragraph 11 of the impugned judgment is quoted as considering the aforesaid facts and circumstances, the award of rupees 26,016, which was directed to be paid on account of 13 days' wages, which was not paid to the applicant by giving him final wage, was rightly adjudicated by the learned Labour Court, and the same does not call for any interference. Another argument has been advanced by the learned counsel for the petitioner with regard to direction to pay interest at the rate of 9% per annum from expiry of the period of 30 days till the date of actual payment. For that, they have relied upon the judgment passed by this court in WPL number 6969 of 2017. This court finds that similar issue failed for consideration before this court in the WPL number 6969 of 2017, and it has been held by this court in paragraph 28 that there is no scope for passing an order for payment of interest over and above whatever was due and it has also been held that the court had no jurisdiction to award any interest in equity, and it was only bound to quantify the amount payable. It was also held that in case the amount was sought to be recovered through certificate proceedings, the statutory interest as applicable to the certificate proceedings will be payable in accordance. This court ultimately had set aside the direction to award interest. The issue being squarely covered by the aforesaid judgment. The direction to pay interest in the impugned judgment calls for interference, and accordingly the direction to pay interest is as concerned. This repetition is partly allowed only to the extent it relates to payment of interest. Same for all?
Number of days would differ, that's
That will
किसी में 15 दिन है, किसी में
Item 10, Contempt Civil 295 of 2024.
You're also trying to pass over the laws just to keep up not to the history. Order is not
Did you go? Did you go to the authority on 21st of October?
I have no instance, so I am seeking passover for
Contempt Civil 295 or 24. Counsel for the petitioner pays for Passover. Close this case on opening Friday. Till the next. Nobody appears on behalf of the state. On behalf of opposite party.
Item 11, Contempt Civil 453 of 2024.
item number 10 will state.
Yes. What is the present status?
Your Ladyship, pursuant to the last order, the petitioner appeared before the medical board and examination was conducted on 23rd of October 2024, Your Ladyship. But the report of the medical board, the show cause has not been filed by the respondent.
What is the status?
Lord, in this case, my lords, I have received a letter on 24 and I require 4 weeks time to file it.
No, what is it? What is it? Letter you have received, what is it?
The letter, it says that the CEO Mahagma, he has been made the Variya Dandadhikari and a member of the flying squad in the elections once.
So,
So, Lord, I require 4 weeks time. Otherwise, I have received
what happened ultimately to his medical board examination?
medical board. This is not the case.
Will not,
This
there
is
is a
the-
confusion
Serial
between
director.
serial 10 and she is serial 11.
You did not appear. I have recorded your absence and the matter has been adjourned. चलिए, आप अपना केस करिए मैडम. You are there in this case. Serial number.
11.
Serial number 11.
Yes.
Ladyship, we haven't filed the show, but we have served a copy upon the petitioner, Ladyship. In this, a medical board was constituted, and it was after the medical examination, the petitioner has been said to be a blind person.
Said to be a blind person.
Blind person.
So
Now,
what is
Ladyship, thereafter, we have forwarded his claim to the authorities, and a decision will be taken within 4 weeks. Now, the decision to the extent, because the new act has come and even the circular has also come of CIL, that nobody will be deprived from the employment if at all there is some disability that occurs during the subsistence of his employment. So he will be adjusted against the same pay scale. There will be no loss of income in his family, and he will be made to continue as per the law.
This is your showcase.
This is my purpose.
So we will just record whatever you are stating,
Yes.
and then we will give it a date for
Yes.
final complaints.
Yes, yes. Ladyship, may kindly peruse also what is
Let's- Have you got the copy of the showcase? Have you got the copy of the showcase, petitioner? Have you served in copy?
Yes, yes. Copy has been served yesterday itself.
No, Lords, I have not received the copy of the show cause. It's not even in the records of the case, Lords. In the online records also, the copy is not showing that any show cause has been filed.
Millard received Abhishek. This may kindly be seen. Receiving may kindly be seen in the.
No, I'm just wondering how callous they can be. Abhishek Srivastav, advocate, enrollment number 7 of 21. Is that your name?
That is my name, Lords.
Your signature? Received copy. Somebody has forged your
I have
signature.
not met with them, Your Ladyship.
Somebody has forged your signature.
In all honesty, Your Ladyship, if I would have received the show cause, I would have honestly stated the same, Your Ladyship. But
Then we'll institute an inquiry that there is a forged signature.
I'll just inquire with
No,
my
it has to be done.
office clerk.
No, it is not. It is not the signature of your office clerk. It is your signature. किसको दिए?
Petition for somebody from his office only, if not he.
See, it does not contain the signature of the person who is receiving it. It only says Mr. Abhishek Srivastav, as if he is the person who is receiving it. His clerk must have received it.
His clerk must.
So you instruct your clerk to
Yes.
make proper endorsement. Who is receiving it and for whose behalf he is receiving it.
Definitely, that has to be.
Right? But it is not like that.
Because even when we receive for, we
Yes.
write and then we receive the copy. We never receive on his name like my signature.
Apparently his signature is slightly different. Maybe your clerk must have received it.
Yes, Your Ladyship. I'll just have to inquire about that, Your Ladyship. Because I have
Learned
definitely have
counsel
not.
for the parties are present. Counsel for the opposite party has submitted that the petitioner has been medically examined and has been found to be blind. She has submitted that the show cause be taken on record And as per the show cause, in paragraph number,
Paragraph 6 onwards.
paragraph 6,
In paragraph 5, it is the medical report we have annexed.
no, you just tell us that what is your further stand.
Yes, my further stand is that he will be continuing in the same stage, but in a post
Just,
that is equivalent.
she has referred to paragraph 9 and 10 of the show cause and has submitted that some time may be granted so that appropriate relief is extended to the petitioner. As per the show cause, 4 weeks time would be sufficient. Considering the aforesaid submissions, pose this case on 29th of November in the supplementary cause list. The show cause giving due relief to the petitioner as stated in the show cause being filed today, which is taken on record, be filed by 27th November.
Obligation.
Petitioner has joined online. It has been adjourned. Next case.
That is
एडवर्स
12.
थोड़ी किए अगला डेट चला
आज का ही ऑर्डर कंप्लाई का था व्यू का आदेश
अब आप लोग दोनों जने कोई नहीं आए तो क्या ही कर सकते हैं मेरा आदेश है वो हम देखेंगे उसकी आप चिंता मत
See,
करिए
since 8 and 9 was tagged, Milos,
8 and 9
Milos,
Yeah,
due
yeah.
to that confusion, Milos, I was not Milos.
which serial numbers
In 10 Milos.
you forget it you did not appear I have adjourned
he has to comply the order. That's
you don't bother about it and parties don't bother why should we bother continue
Item 12, Contempt Civil 593 of 2024.
Second.
कुछ
Non-appearance.
adverse order थोड़ी किए
Non-appearance.
non-appearance would be there we will not delete it
Lord, in compliance to my lord's last order, my lord, my client has said that some payments have been made, my lord. What are the payments made and under what head, my lord? That is
Just
not
a
clarified. Nothing has been.
As per the instruction received from the contemptor lordship, all payment has been deposited in account of petitioner lordship. Approx 18
Can't
lakh
do
of
anything.
answer.
Compliance report will be filed. my lord.
compliance report क्या आप तो खुद ही बोल रहे हैं पेमेंट मिला है
Some payments, but what are the payments? My lord, whether area, it is a areas of salary or
if you
areas
have
of.
any further grievance you will have a separate cause of action with regard to quantum of payments
With that liberty.
Contempt Civil 593 of 2024. Counsel for the parties are present. Counsel for the petitioner submits that the petitioner has received certain payment after the last order, but he has not been able to verify the quantum. The learned counsel for the opposite party has submitted that the entire dues has been
Yes,
paid.
lordship.
Considering the aforesaid submissions, this court is not inclined to proceed any further in this contempt case. Accordingly, the contempt proceedings are hereby dropped. If the petitioner has any grievance with regard to quantum of the amount paid, it will be open to the petitioner to agitate his grievance in accordance with.
Item 13, Contempt Civil 631 of 2024.
in view of last order. Last order, we have said that it is the case about the appointment of the teachers. On the basis of matriculation certificate issued from the Allahabad, this candidature was rejected. But after passing a LPA judgment, my lord has said, then we have to take this. The director of secondary education has not been made a party in this case. He has to take this. So we have seek instruction from the director. He will be made a party. We will file suit.
We do not know.
Lordship, there was direction on DSC and we have made them him a party. On the last occasion,
Who
notice.
was directed?
Director DEO
Before respondent number 2.
Two.
Who was respondent number 2?
is the DEO,
Director Education.
district education.
District Education.
Yes.
So,
He said that in a policy matter they have to take decision from the department. instruction. They have sent the letter
What
to
instruction?
give instruction on the director. And in LPA also, on which we have to rely. In that order also director was made.
Which LP?
LPA on whose
Arising out of this order?
no,
We
on
are not
whose
bothered
basis
about
we
it.
have to pass the order.
We do not know. Why is he sitting over? On 25/4/24, he should have completed all the formalities. Where is the letter of the opposite party district education officer referring the matter to the director education? Will summon director education to explain as to why is he acting in such a manner that the orders are frustrated. Where is that letter?
This election B.
To the annexure A,
Page 14.
annexure B. Okay. Where is it that you have referred it to the director?
This first page, page 14. जिला शिक्षा पदाधिकारी से मिलेगा सेवा में निर्देशक माध्यमिक शिक्षा.
So,
All the order has been quoted here. Thereafter, in last paragraph, they seek instruction.
the show cause was filed when? 24/9. Right? Annexure B. Okay. Who is the person, director secondary education? What is his name?
Aditya Ranjan.
Aditya
Your
Ranjan.
leadership asked me to inquire on the last occasion. It's Aditya Ranjan.
Where does he sit?
Project Bhavan.
Project. Contempt Civil 631 of 2020. Counsel for the parties are present. Counsel for the opposite party has referred to the show cause dated 23/9/2024, filed by the opposite party number 2, and has submitted that the opposite party number 2 is seeking instruction/guidance from the higher authority, namely Director Secondary Education, Jharkhand, and for that purpose a letter number 988 dated 9/7/2024 has been forwarded. The affidavit was filed by the show cause was filed by the affidavit dated 23/9/2024, and it appears that in spite of letter dated 9/7/2024, the aforesaid authority, namely Director Secondary Education Jharkhand, did not issue necessary direction, and consequently it appears that he is sitting tight over the matter and he is causing hindrance in compliance of order passed by the state. At this, the learned counsel for the petitioner submits that the present incumbent, namely present incumbent of the Director Secondary Education is Mr. Aditya Ranjan.
School Education and Literacy Department.
Director Secondary Education, School Education and Literacy Department, and has his office at Project Bhavan Ranchi. He seeks permission to add in as opposite party number
3.
3. Let Mr. Aditya Ranjan, Director Secondary Education Jharkhand, वो पूरा डिटेल दे देंगे. Having his office at Project Bhavan, be made opposite party number 3 in the present case. Let notice be issued to the opposite party number 3, newly added opposite party number 3, as to why a contempt proceedings be not initiated against him for causing hindrance in compliance of order passed by this court. Let the notice be issued to the officer in charge of the concerned police station, for which requisite be filed by the petitioner by 11.
In course of day, I'll find.
In course of
In this
in the
matter,
course of
in this matter,
Hold this case on opening on 22nd of November.
we used to send later.
चलो.
First time it is made.
आपके जब चौपास फाइट करने आते हैं ना, उसी समय पूछा करिए कि क्या स्टेटस है.
Lord, if they will take that excuse in their so cause also, let secretary be sued because secretary was a party in the main writ petition.
तो सेक्रेटरी को ही तो पार्टी बनाई है, कौन है?
Secretary School Education and Literacy Department.
उन्हीं को तो नोटिस किया.
मेरा डायरेक्टर को गया है. ये लेटर से.
Later
आपने
was
लेटर किसको भेजा?
director को ही भेजा.
इन्होंने लेटर डायरेक्टर को भेजा है, but they will what excuse they are
तो
taking
फिर
now?
उसके बाद सेक्रेटरी साहब को नोटिस कर देंगे, उसका क्या चाहिए?
ये लेटर.
They can take a stand. जब जो है बॉल डायरेक्टर के कोर्ट में पेंडिंग है, जिसके कोर्ट में बॉल जाएगा उसको हम लोग नोटिस करेंगे.
Director is the complaint authority.
डिसीजन फाइल कर दीजिए, बात खत्म हो जाएगा.
Item 14, Contempt Bill 651 of 2024.
एक चीज और बोल देते हैं, अगर आप उनका एफिडेविट फाइल कर देंगे प्रायर टू द नेक्स्ट डेट, ठीक है, अभी तो आज ये तो नोटिस फाइल करेंगे, कोर्ट बंद हो जाएगा. ओपनिंग में भी अगर कोई एफिडेविट फाइल करके मेंशन कर देंगे, देन ऑल्सो यू कैन इंटीमेट दिस कोर्ट. नोटिस जाने की जरूरत नहीं होगी. ठीक नहीं लगता है ना?
मेरा कहना ये था कि फर्स्ट टाइम मेड अ
नहीं.
पार्टी.
आप
हम
लोग
लोग
का ये सब
भेजते
जो
हैं लेटर.
एटीट्यूड है ना,
हम
एक
लोग
शोकॉज फाइल करने का तरीका, आई डोंट लाइक इट. आप लोग का काम है ऑर्डर कंप्लाई करना. उसमें एक चीज और लिखिए, ही विल बी फ्री टू एंगेज हिज इंडिपेंडेंट काउंसिल.
Item 14,
यस पिटिशनर.
I have just received
Pursuant to the last order, we have filed the affidavit is ready. We are filing it today.
What are you filing? What is your reply?
That they are entitled for monetary
So
compensation.
that is already there.
We have given the chart that they will be entitled at the rate of rupees
So we are
39,000.
not bothered about the rate. Have we decided the quantum also?
Yes, Your Lordship. Annexure A, page 6.
No, I just want to know, in the order, have we decided the quantum
No,
also?
Your
We have
Lordship.
not.
Representation,
Okay. So you have ultimately decided that they are entitled.
yes.
Okay. Why don't you pay?
We will pay the arrears within 1 year period.
Within 1 year from today?
Arrears, Your Lordship.
1 year you will take.
10 installment because it is 30 lakhs.
Have you gone bankrupt or what?
No, Your Lordship.
Her entitlement you paid?
We will pay it within.
No, we are not going to sit like that.
Yes.
How much time do you need to pay?
Arrears, Your Lordship, 1 month time will be needed.
1 month only. I
Yes.
heard 1 year.
1 month. In affidavit, we have stated 1 year, Your Lordship.
they have stated in para 7 Your Lordship that arrears shall be paid within 10 installment in 1 year period.
I've told them to pay it within 1 month, Your Lordship. They have requested.
I'll record your undertaking. Go and seek instruction.
Yes.
I'll record your undertaking. You say you seek instruction on phone.
Yes,
On
Your
phone in
Lordship.
the sense WhatsApp.
Yes.
Something in writing.
Yes, Your Lordship.
You have taken instruction.
No, that I'll
Go.
take instruction.
Come in 5 minutes. I'll record your undertaking.
Yes.
Item 15, Contempt Bill 845 of 2024.
order, Your Lordship, to seek instruction whether they are going to make payment or not, Your before Diwali vacation, Your Lordship. They have passed the reason order, Your Lordship, and they have admitted the claim of the petitioner, Your Lordship. Kindly have a look to the page number 20, Your Lordship.
Yes, where is the opposite party?
I have informed Your Lordship.
What is your instruction? They have not been paid so far.
No, Your Lordship.
Who is the counsel?
Praveen of Saudi.
Information may not be sufficient. Payment is.
Yeah, just one. That's it.
We'll just pass it over.
Item 16, Contempt 930 of 2024.
Change की करो।
16.
My lord, in this case, my lord, we have filed a CMP application for extension of time, my lord, for compliance of the order.
What is the CMP number?
CMP, in fact, my lord, we have got the filing number, my lord. Filing number 11289 of 24.
11289.
This was filed on 22/10/24.
2210.
We have explained the reasons so far as the delay is concerned.
Contempt Civil 930 of 2024. Counsel for the parties are present. The learned ASDI submits that a CMP seeking extension of time to comply the order of this court has been filed through filing number 11289 of 24 on 22/10/24. Let this matter be posted with the aforesaid CMP on 22nd of November 24. In the meantime, it will certainly be open to the opposite party to remove the defects
Yes,
in the execution.
Madam, can we see the operative part of the order, madam?
CMP फाइल किया तो क्या बोलेंगे?
Madam, at least so cause.
आप appear हो जाइए CMP में. फिर CMP में आप बोलेंगे हम appear वकालतनामा लेंगे ये करेंगे.
नहीं हम तो कॉपी सर्व हो गया. I am ready to
CMP
appear
आने
because that is just to
CMP आने
frustrate the
दीजिए,
order
we
of
will
this
see.
honorable court. There is nothing in the CMP.
From daily list of final disposal item 2, WPL 2363 of 2010.
प्रोजेक्ट के लिए बात किए थे
क्या
सर, इसमें प्रोजेक्ट के लिए बात किए थे मगर रिफ्यूज किए, बात नहीं। अभी फाइल कर रहे हैं कि हम 15 लाख रुपया दें, करीब करोड़ों रुपया मेरे पैसा से बना लिए। अब कहते हैं जो 40 लाख के आसपास आता है, कहते हैं 15 लाख रुपये हमसे प्रोजेक्ट देने के लिए तैयार।
नहीं देखिए आप लोग का प्रपोजल पे हम लोग कुछ भी इट इज नॉट एक्सेप्टेबल टू यू. एफिडेविट फाइल किए हैं, एफिडेविट फाइल करके दीजिए. रजिस्टर किया ना, इसका जवाब फाइल करिए. राइटिंग में चाहिए हम लोग. आप लोग का वर्बल सबमिशन से हम नहीं मानेंगे. ही हैज गिवन अ प्रपोजल,
दिए हुए हैं,
इसमें दिया ना.
क्लाइंट से बातें किए ने, प्रपोजल दिए, वहाँ बात करने की बात है, कभी तो बात कर लेते हैं, कभी तो बात नहीं किए। अभी कोर्ट में के बाद एफिडेविट फाइल कर रहे
कोई
हैं।
बात नहीं, आप रिस्पॉन्ड कर दीजिए ना.
लंबा खींचा 10 से खिंचा रहा है, हमारे पैसा के करोड़ रुपया बना रहे हैं, हमारे रुपये करोड़ रुपया, हम तो सफर कर रहे हैं।
10 से क्या किसके कारण
टाटा बना लिया, मेरे रुपया का टाटा करोड़ रुपया बना लिया। टाटा पैसा का मेरा कहीं रखा हो रहता, मिलता कि नहीं मिलता, इसी करोड़ रुपया हो जाता पैसा। टाटा कंपनी कोई भी कंपनी करता है, बिजनेस करता है, पैसा का थोड़ी कहीं रख दिया है, सड़ रहा है, कहीं पर रात दिन दुनी चौगनी हो रही है।
आपका अपना पर्सनल केस तो नहीं है ना?
पर्सनल केस नहीं,
ऐसे
तो पार्टी
पूछ
दिया है, एज ए पार्टी दिया हमको, एज ए पर्सनल काम करने के लिए, नहीं कि दूसरे के भरोसे काम करने के लिए।
आपको इसका जवाब फाइल करना है कि नहीं करना?
नहीं करेंगे कौन सी
इसका
जो
जवाब
खर्चा होगी उसका पैसा कम, पैसा नहीं इसके पास।
ठीक है, लिखा देते हैं कि आपको नहीं करना है इसका जवाब.
नहीं
तो हम पार्टी को नोटिस कर देंगे.
हाँ, नोटिस कर दीजिए, आ जाएगा यहीं पर बात कर लेंगे। बढ़िया बात है, बहुत अच्छी बात होगी।
आप कौन हैं?
मैं वकील ही हम तो
आप जरा हट जाइए, एडवोकेट ऑन रिकॉर्ड समझो।
हाँ
आपको इसका एप्लीकेशन का एफिडेविट का जवाब फाइल करना है कि नहीं करना?
नहीं मैडम, अब क्या करेंगे? नहीं करके क्या फायदा? 2010 से देख रहा
आपने
हूँ।
इंस्ट्रक्शन लिया है कि फाइल
लिए हैं, तो लेने के लिए कल बैठे हुए थे, कल बोले थे रात को बात करेंगे, लेकिन बात तो कुछ हुआ नहीं।
नहीं, आपसे ये पूछ रहे हैं कि आपने ये एफिडेविट पर आपने अपने क्लाइंट से इंस्ट्रक्शन ले लिया है कि
नहीं, एफिडेविट तो अभी मिला ना मैडम।
अभी मिला ना?
यस।
तो आप इसके बाद उनसे बात करना तो पड़ेगा ही ना आपको। एफिडेविट दिए हैं तो आपको उनसे बात तो करना चाहिए ना। आपको क्या जुरिस्डिक्शन है बोलने का कि नहीं एक्सेप्ट करेंगे? इंडिविजुअल कैपेसिटी, राइट? आप एक बार बात कर लीजिए, जवाब देना है कर दे दीजिए, नहीं तो हम लोग अपने आराम से मेरिट पे डिसाइड करेंगे। ये जो आप लोग का कहना है ना कि 2010 से ये केस यहाँ पेंडिंग है, ठीक है, कोर्ट के कारण नहीं पेंडिंग है। कितना एडजर्नमेंट आप लोगों ने लिया है आपने देखा है? लिखे हम लोग आप लोग का एडजर्नमेंट का डेट्स?
एडजर्नमेंट हम लोग कहाँ लिए?
हाँ?
नहीं तो
कैसे नहीं?
कोई एडजर्नमेंट हम लोग नहीं लिए, जो पेटिशनर लिए एडजर्नमेंट।
तीन 2/2022 को आपकी तरफ से एडजर्नमेंट हुआ, ठीक है? इसके पहले 8/2/2021 को आपकी तरफ से कोई अपीयर नहीं हुआ, राइट? उसके पहले 21/10/2019 को आपकी तरफ से कोई अपीयर नहीं हुआ। उसके पहले 26/7/2019 को it has been submitted by both the councils that effort is being made to settle the dispute, and for that purpose 2 weeks time was spent. तो सेटलमेंट ऑफ डिस्प्यूट के लिए तो डेट 26/7/2019 से ही चल रहा है ना, ठीक है? इसीलिए कोर्ट पर हल्ला करने से कोई हासिल नहीं होने वाला। आप लोग का भी जो डेट्स है ना, आप लोग के कारण भी डेट्स पड़ा है। ये जो आप लोग बोलते हैं ना 2010 से यहाँ केस पड़ा हुआ है, आप उसका एक रिस्पॉन्स फाइल कर दीजिए। ना बोलिएगा तो भी कोई दिक्कत नहीं है, हम लोग डिसाइड करते हैं, ठीक है? और अगला डेट में टाइम मत मांगिएगा, हम टाइम नहीं देंगे। आप जवाब फाइल कर दीजिए, उसके ठीक 2 दिन बाद हम मैटर को प्लेस कर देंगे और आप लोगों से उनके प्लेस डिसाइड करेंगे। इसमें रिकॉर्ड आया है? रिकॉर्ड वुड बी रिक्वायर्ड। अभी तक रिकॉर्ड भी कॉल फॉर नहीं हुआ, और आप लोग को ये भी होश नहीं है कि रिकॉर्ड भी कॉल फॉर कराना चाहिए। मैटर अभी रेडी ही नहीं है फाइनल हेयरिंग। WPL number, records would be required or not required?
I will close all the road agreements for both.
You can,
From my
आप
side,
बताइए
not
आपको
required.
रिकॉर्ड की जरूरत है कि नहीं? आधा सुनने के बाद हम रिकॉर्ड के लिए एडजर्न नहीं करेंगे, जरूरत है। WPL number 2363 of 2010. An affidavit has been filed today during the when the case is taken up. Counsel for the petitioner has submitted that the petitioner is making an offer of payment of an amount of rupees 15 lakhs as full and final settlement, which would be inclusive of amount of corporate wages and also extra amount as goodwill gesture from the petitioner company. Such statement has been made in paragraph 8 of the show cause. When the matter was earlier taken up on 26/7/2019, it was submitted by both the councils that efforts were being made to settle the dispute and matter was adjourned. And thereafter it has remained pending before this court. The present affidavit has been filed pursuant to order dated 15/10/2024, wherein a submission was made by the petitioner that they were willing to furnish a proposal before this court for settlement. And upon giving such proposal, if it is acceptable to the respondent, then the matter can be disposed of in terms of the proposal. Since the affidavit has been filed today during the court proceedings, so the counsel for the respondent has prayed for some time to respond to the affidavit. कब तक कर देंगे बताइए?
1 week में कर देंगे, just after let's say.
The affidavit we filed by 11th of November. 11th of November. Post on 12th. In the supplementary cause list. If the proposal is not acceptable to the respondent, then an appropriate order will be passed for calling for the records from the council, so that the matter is ultimately disposed of, which has remained pending before this court since then. Appearance दे देंगे please.
For admission item 3, WPC 351 of 2019.
I believe sometime after vacation.
Sorry?
After vacation.
Which vacation?
Diwali.
Diwali vacation. This year, next year?
This year.
What is it?
मतलब rising out of मतलब BPLE proceeding मतलब and मतलब petitioner has encroached मतलब a khas mahal land मतलब and without having any right title or interest
Is it an
मतलब
appealable order?
Your Lordship, senior is not feeling well.
Senior is not feeling well. Who is your senior?
PPM sir.
He has not come to the court today.
even the appeal has been dismissed मतलब
Appeal has been dismissed.
Malice.
Is it under challenge?
that is under challenge.
Appellate order is under
Malice.
challenge. Now they don't have any remedy.
Malice.
It's a Khasmal land admitted.
Malice.
When will he be available?
After vacation.
Sorry?
After this Diwali vacation.
Give a specific date, madam.
11th or 12th of November.
12th November he will be available. Otherwise you argue the case on 12th.
No, ma'am.
No means what? You ask him. That is why I'm asking you to choose a date.
12th November.
Okay? Sure.
Yes, ma'am.
Give your name.
Sakshi Charu.
Sakshi.
Sakshi Charu. CHAR.
MS Sakshi Charu. Advocate submits that Mr. P.P.N. Roy, senior advocate, is not well and therefore he is unable to argue this case today. Though he has come to the court. Correct? He has come to the court.
But he's not feeling
That's right. Though he has come to the court. She submits that the matter be posted on 12th of November. And on that day, she will not seek any adjournment. Post this case on 12th of November under the heading for final disposal to be taken back to 15th.
And for respondent number 4.
Council अपना appearance.
Item 4, WPC 388 of 2019.
In this case, we have challenged the order of cancellation of arm license of the petitioner on the ground that no proceedings was initiated, no show cause notice was given. Your Lordship, from the same order, another individual's arm license was cancelled. However, on for that particular individual, the license has order cancellation has been set aside. Cancellation order is on page 23.
Page number?
23. License was cancelled on the ground that there is an FIR.
You say by the same order there are two cancellations.
Yes.
Is that correct?
Yes, ma'am.
So it is covered by this order then?
Yes, ma'am. Same.
License cancel मिला.
We have annexed the license.
Who is the licensing authority?
It is there in annex to 1 membership. That is at page number 20. By district magistrate. District town magistrate.
Which district?
Gumla Majo.
This is Zuleshwar Singh.
Yes.
There was some inquiry done.
Yes, ma'am. Come in
Just
the
mentioned.
Your Lordship, your ladyship, the inquiry was done with respect to an FIR which was lodged on the petitioner's brother. And
You just see page number 23, second paragraph. Read it please.
पुलिस अधीक्षक गुमला के प्राप्त अनुशंसा एवं बक्सिया थाना के जांच प्रतिवेदन अनुसार ओमप्रकाश साहू उर्फ पप्पू साहू पिता गोपाल सोएंसो शस्त्र अनुज्ञप्ति संख्या नंबर सोएंसो तथा दुलेश्वर सिंह पिता सोएंसो के नाम से निर्गत शास्त्र संख्या स्वयं को रद्द किया जाता है.
So this inquiry is not relating to a separate inquiry.
Your ladyship, this inquiry it has come in the supplementary affidavit, counter affidavit about the inquiry that was taken.
Where is it?
Counter affidavit dated 18/6/2019. It starts
Just a
from
moment. 18/6/20.
19.
Where is the inquiry?
That starts from your lordship annex number 1, page 20. It's an FIR, your lordship. Initially, an FIR was lodged against the petitioner's brother.
Annexure A, page 20.
Yes. And subsequently, in page 21, your lordship.
No, in page 20, he is making an application that the arms license should be cancelled.
Yes, your lordship. For that only, page 21.
Who is this applicant?
Chandrasekhar
Singh.
Singh.
Right?
Yes. In page 21, your ladyship, he has specifically stated against whom he wanted the arms license to be cancelled. That was शांति सेना के नाम से जो हथियार है उसका लाइसेंस रद्द किया जाए एवं अवैध हथियार जब्त किया जाए. Page 21.1.
That's right.
Then your lordship, in annexure B, that is page 22, that was sent to Thana Prabhari. In that also, it has been stated कि आवेदन पत्र में उल्लेखित शांति सेना के नाम से जो हथियार है उसका लाइसेंस रद्द किया जाए और दोनों अभियुक्तों के संपत्ति की निगरानी की जाए. Here the accused were the petitioner's brother.
That's right. Thereafter what happened?
And thereafter, your lordship, ladyship, page 23. This is the report, if I may be permitted to read. उपरोक्त प्रसंग एवं विषय के संदर्भ में
So there was a separate inquiry conducted.
Yes, and the and why the license was cancelled, stating that they have an apprehension because my brother is arrested. I may use the arms against the complainant of that case.
Where is the जांच प्रतिवेदन?
That this is my
कहाँ है जांच प्रतिवेदन?
यही है पेज 23. जांच के क्रम में पाया जाता है नीचे
तो जांच प्रतिवेदन कहाँ है?
यही बस यही
ये तो फॉरवर्डिंग है.
दिस इज द
यही है क्या?
Besides that, your ladyship, in another counter affidavit file dated 31/10/2023, there has been a specific statement made in paragraph number 9, stating that perused the record belonging to arms license of the petitioner and found that no any notice was issued to the petitioner before revoking his arms license file number 534.
That's right. But we will pass an order because no opportunity of hearing was granted to you. But there has been certain inquiry. You may need to respond to that. So you appear before the authority and they will give you opportunity of hearing and pass on.
Your ladyship, we also have judgments with respect to that mere apprehension of.
So with that you satisfy that. Who would be the authority? Who has passed the order of cancellation?
DC.
DC. The learned
DC Gunda.
The learned counsel for the parties are present. This writ petition has been filed for the following relief. The learned counsel submits that no opportunity of hearing was granted to the petitioner before cancelling the arms license. She has relied upon an order passed by this court in WPC number 4110 of 2019, dated 25th of July 2024, and has submitted that arising out of the same impugned order, contained in memo number 534 dated 2010-2018, 2 arms licenses were cancelled and the order dated 25th, an order passed in WPC number 4110 of 2019 has set aside the cancellation of license with respect to Om Kumar Singh. Counsel for the respondent has submitted that the records of the case reveal that some inquiry was conducted prior to cancellation of license, but it is not in dispute that the petitioner was not granted an opportunity of hearing. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, this court finds that the arms license of the petitioner has been cancelled without granting an opportunity of hearing to the petitioner. Though the records of this case reveal that some inquiry was conducted, and this court is of the view that the petitioner was required to be given an opportunity of hearing before cancellation of license. Consequently, the impugned order cancelling the license of the petitioner cannot be sustained in the eyes of law on account of gross violation of principles of natural justice. The matter is remitted back to the Deputy Commissioner Billa, who has passed the order of cancellation, so that a fresh order be passed after granting an opportunity of hearing to the petitioner. Inquiry report इसी में है ना?
जी.
The Inquiry report, etc., has already been placed on record in this case. The petitioner shall appear before the respondent number 2 on 11th October, 11th November, and reasoned order be passed after granting an opportunity to the petitioner within a period of 1 week from the date of appearance. 11 तारीख को नहीं हो पाएगा इलेक्शन का चक्कर है।
इलेक्शन के बाद ही कब कंप्लीट रहेगा अच्छा रहेगा।
इलेक्शन के बाद नहीं, ये सब काम तो इलेक्शन के पहले होना चाहिए ना, सारे काम इलेक्शन के पहले होना चाहिए। कुछ एक्सटेंशन आपको लगेगा तो आप विदिन अ वीक फ्रॉम द डेट।
If I may be permitted to point out a fact from the order of setting aside of the other purchase, etc. Your legation in that order, it has been specifically mentioned that accordingly the order dated so-and-so contained in memo number so-and-so is hereby quashed and set aside. It has not been specifically mentioned with respect to that.
I am not inclined to pass that kind of order because there is an inquiry on record ex parte. So when an order is passed on account of violation of principles of natural justice, order having been passed on some inquiry, it cannot remain open ended. That is my view, right? The order be communicated to the petitioner forthwith.
Password case from supplementary list item 14, contempt 0651 of 2022.
We have computed the arrears amount. It comes to 31 lakh.
21 lakh.
31 lakh 79,000.
31 lakh 79,000.
839 rupees.
8.
Till the month of September 2024.
September 24.
4. From February 2016 to September 2024.
So you pay in 1 month?
By first week of January, they are saying the arrears amount will be paid. And the regular monetary compensation for the month of October, they will be paying in the
What
first
was the direction of this court?
to decide the representation of the petitioner.
The learned counsel for the parties are present. You have filed your show cause also?
Yes, Your Lordship.
Counsel for the respondent, opposite party, has filed show cause and has referred to paragraph number
7.
7 of the show cause, wherein the entitlement of the petitioner to receive monetary compensation is not in dispute, but it has been stated therein that arrears shall be paid within 10 installments in 1 year period. However, counsel for the opposite party has sought further instruction from the opposite party number 2, and on instructions he submit that the entire amount would be paid to the petitioner by first week of January?
Yes.
By first week of January 2025, and the monetary compensation relates to the period from February 2016 to September 2024, and the amount as quantified comes to rupees 31 lakhs 79,008. You have her bank account details?
Yes, I have given.
You have given to whom?
Details. We don't have.
Master on the last occasion. I have given all details on
कुछ mismatch था.
right.
आपका नाम में कुछ मिसमैच था, इसीलिए हम लोगों ने इसको ऑर्डर में नहीं लिया. You just go to them. कुछ हम लोग को लगा कि ऐसा नहीं कर सकते हैं. You satisfy them about your identity, That is important.
Yes.
At this, the counsel for the petitioner has submitted that he would approach opposite party number 2 and provide him the necessary details regarding her bank account. Unnecessary मत करो बात.
नहीं no unnecessary. तो उसी दिन reason order निकाल दिया.
Pose this case on. She must have approached. That is why you have passed the reason.
We have communicated the letter.
थोड़ा हम लोग को लगा कि original letter लेके जाइए. You must have received the original letter. You should take the original letter. Pose this case second week January का Friday. The supplementary show cause be filed prior to the next date.
Password case item 15, contempt civil 845 of 2024.
Yes.
All the process for the payment petitions have been made and pending has been sent to the treasury. The show cause
Has been sent to the
treasury for the payment. The show cause has not been filed as the director is on leave and only the director secretary is the party in this case. So it's pending for the filing the show cause.
director is a necessary partner.
Only director is necessary party.
So on the last date, the amount was, it was submitted that there should not be any reason for
All the
non-remittance.
process has been done. The payment is they have sanctioned the payment also and sent to the treasury for the payment. Today
ट्रेजरी में बंदा क्यों जाएगा पैसा लेने? नहीं जाएगा. आप इनको रेमिट करिएगा.
हाँ remit कर रहे हैं. आज या कल इनके अकाउंट में आ जाएगा.
आ जाएगा ना?
हाँ
लिखे?
हाँ.
Contempt civil 845 of 2020. Counsel for the parties are present. Counsel for the state submits that necessary steps have already been taken for payment to the petitioners and due.
And we'll also file the show cause after
She submits that the payment will be remitted to the account of the petitioner within a couple of days. She has also submitted that the matter be adjourned so that it may be brought, the payment, the factum of payment be brought on. Post on 12th November, 12th November 24, 13th November 20. 13th to छुट्टी होगा. 12th November 24 in the supplementary cause list. The supplementary show cause be filed. The supplementary show cause with regard to the payment be filed by 11. आप भी इंस्ट्रक्शन ले लें. दीपावली के
पहले हो जाएगा. आज या कल तक.
From Delhi list item 5, the WPC 485 of 2019.
At the outset, I want to mention that a similar matter, LPA is pending, wherein judgment has been reserved by this court.
Because I am not pressing for final adjudication, because I am only pressing my IA. Because we have challenged the illegal and arbitrary demands of Steel Authority of India Limited for lease renewal. In their counter affidavit, they are relying on a valuation report, on the basis of which say that this is the demand, and they have not annexed it. For that, I filed an IA of my own to give a direction on them to just give us a copy of valuation report. That's it. I'm just pressing
And
this.
file a counter affidavit or a response to the IA or leadership. If it is permissible, we will file.
क्या order? Which order is under challenge? Similar order?
Your leadership LPA 450 of 2022, and judgment has been reserved
I have a
on
copy of
25/1/2023.
I have a copy.
Writ order.
There are
This is in a
multiple
similar
LPAs.
matter, Miles.
Similar matter.
The coordinate bench of this honorable court had held that the valuation which they are relying on is absolutely arbitrary and therefore had struck down the demand, against which they have filed an appeal malice. So Miles, now what they are doing is they are not annexing the valuation report. They don't want to expose their arbitrariness. Deliberately they are doing it. So that is why I preferred an IA, so that at least let them bring the valuation report so that I can answer whether it is arbitrary or not.
एक केस में हम भी ऑर्डर किए थे
मतलब इन शोभना हो जाता
इसमें क्या हुआ
that appeal is pending, there is no stay. There is no stay in any of these appeals.
So you have not informed the court that there are two different orders of this court.
That order is on a different footing. This order is exactly on that same valuation which they are relying on.
The learned counsel for the parties are present. It has been reported that in similar matter being LPA number 450 of 2020, arising out of similar matter, LPA number 450 of 2022 has been finally heard, in which order is reserved.
On 25/1/2024.
On
25 January
on 25/1/2024.
2024.
Counsel for the petitioner has submitted that one interlocutory application being IA number
10844
10844
of 2024.
2024 has been filed, seeking a direction upon the respondents to file a copy of the valuation report on the basis of which the demand has been raised upon the petition.
Your Lordship, another IA is also pending wherein they have sought amendment of the reputation.
Why amendment?
They have also relied on a board guideline in their counter affidavit. So we are challenging that board guideline by way of amendment.
That is IA number?
This is IA number 10843
10843
of 2024.
It is submitted that another IA seeking amendment of the petition has also been filed, being IA number 10843 of 2024, wherein the resolution of the board annexed with the counter affidavit is under challenge. Counsel for the respondents prays for time to file a counter affidavit to both the interlocutory application. There could be no reason not to annex a copy of the valuation report on the basis of which the demand has been raised upon the petition.
I'll seek instruction.
In case there is any legal impediment, that should be specifically spelled out in the contract. We'll deal with your legal impediment. When to be posted?
4 weeks time maybe not.
Post on 3rd of December. 4 weeks हो जाएगा?
Yes.
Item 6, WPC 603 of 2019.
Your Ladyship, this is an IA for substitution of deceased
Who has
respondent.
expired? Deceased respondent.
Respondent number 13, namely Pramod Kumar, on 20th of April 2024.
IA number?
IA number is 10843.
Pramod Kumar.
Yes, Your Ladyship. 10843.
One 0556 application for substitution of deceased respond number 30. 108 कहाँ से?
Sorry, Your Ladyship, 10556.
IA number 10556 of 2024. Counsel for the petition submits that the respondent number 13 has expired on 24/2024, and therefore petition has been filed for substitution. He refers to paragraph 3 of the interlocutory application to submit that the respondent number 13 has left behind his widow and his son, and the details have also been furnished as under by the three purported. Issue notice to both the proposed legal heirs of legal heir/legal representative of respondent number 13, namely Bamli Gupta and Pratik Pramod Gupta, for which requisite we filed Maharashtra through speed post. Speed post. In the interlocutory application as well as the main requisition, दोनों में फाइल करिए, इनको क्या ही पता होगा क्या चलता है. Requisites you file by 11th of November. We filed by 11th of November. Posed this case on 10th of December, awaiting service report. Office is directed to prepare appropriate office note with regard to speed post delivery. वो ट्रैक वाला ऑर्डर करेंगे. आपकी किसी तरफ से
State. Respondent unitation.
Which respondent?
9, 8, 9, 10.
Private respondents.
Yes, sir.
All the private respondents.
8, 9, 10 and 11.
13 you were not representing.
No.
Are you sure? ये ऐसे ही बोल दिया. अपना ठीक से लिख
8, 9, 10.
8, 9,
10, 11.
8, 9, 10, 11. Counsel for the respondent number 8, 9, 10, and 11 is present. What about other respondents?
They are the former respondents.
We'll see next. आइए early hearing का फाइल किया हूँ. आइए नंबर
6840/2022.
आइए नंबर 6840 of 2022 seeking early hearing of this petition is closed as the date has already been fixed.
Also, Your Worship, the interim order dated 18 July 2029 may be extended.
18 July 29 आ गया क्या?
May be extended. Your Worship.
18 July.
18 July 2019.
Was it extended on last date? कब तक extension?
Yes, Your Worship, was extended.
Right.
Not extended on the last.
Yes, sir. Prayer ही मत करिए.
Next.
क्या हो रहा है? What is happening? कुछ नहीं हो रहा ना? यहाँ कुछ होता नहीं.
From supplementary list for final resolution of item 1, WPC 3423 of 2015, along with the 2 to 5.
Yes, sir. You have seen the judgments? We will look at the judgments also.
My lords, I have only one submission to make, my lords. One issue, my lords, I am raising. That, my lords, the petitioner has accepted that he falls under the special package for the mega industries. So, my lords, he is claiming a part of the benefit as per the special package, and for the rest, he is claiming, my lords, under the general clauses, my lords. So, my lords, my humble submission is it possible, my lords, accepting a part of the notification and not accepting the other part, my lords? My lords, may kindly see, my lords, the general provisions, my lords, 29.3, my lords, page number 28 of the convenience compilation, my lords.
Yes.
Yes, my lords. My lords, 29.3, my lords. Capital investment incentive. The capital investment incentive shall be admissible to small and medium scale industries. The details of such incentives are as follows. So, my lords, if he is claiming the benefits under the industrial policy as such, my lords, he is not eligible to get capital investment incentive because
Admittedly, he is not neither a small scale industry nor a medium scale industry. Then, my lords, for that,
under the general category, he is absolutely ousted from capital investment.
yes, my lords.
This is what you want to
yes,
say?
my lords. And he has got capital investment incentive only because he has applied before the authority accepting the special package for mega industries, my lords. My lords, then, my lords, I would like to, my lords.
He cannot have the best of both.
Yes, my lords. That is the crux of the matter, my lords. Page number 29, my lords. No, my lords. Page number 30, my lords. Mega units. 29.11. Special packages shall be formulated for the new projects with an investment of more than 50 crores on case-to-case basis through direct negotiation with prospective investors. So, my lords, he has claimed himself to be a mega unit, and my lords, he has accepted the special package for the mega industries, which my lords will find at page number 42.
It is not in dispute. We have recorded. Yes.
Yes, my lords. So, my lords, 42, my lords. उसमें क्या है, my lords, कि other than the capital investment subsidy which was granted to the small scale and medium scale as per the general clauses, my lords, इसमें we are granting to the mega industries, and there is a form which he has filled up, and he has got capital investment subsidy as per the special package, my lords. And now, my lords, the अन्य अनुदान जो इसमें special package में ही है, my lords, for that he is saying कि now he is there, since there are no negotiations, so leave that part and I should get it from the general clauses, my lords. My lords, इसका अन्य अनुदान देख लेते हैं, my lords. My lords, page number 44 of the convenience compilation.
First, you have referred to page 28.
Yes, my lords.
Then you have referred to page 30.
Yes, my lords.
Then you are referring to page number?
Page number 42, my lords. My lords, ऊपर में ही they have written it only, my lords. मेगा औद्योगिक इकाई के लिए विशेष पैकेज. My lords, उद्योग विभाग का ये आदेश है. उसमें, my lords, without going into the details, my lords, it is applicable to the mega industries, my lords, and we have given this पूंजी निवेश प्रोत्साहन अनुदान for the treating him to be a mega industry, for which he has in fact applied also, my lords, in the form which in which they had to apply, and we have granted them. That is not in dispute.
Where is the application?
Yes, my lords. That, my lords, I'll come to that, my lords. That is, they have annexed the rules, my lords. I'll come to that. इसी में, my lords, may kindly see page number 44, my lords.
First, page number 42. Which specific portion you want?
This में, my lords, पूंजी निवेश प्रोत्साहन अनुदान.
Okay.
So this is the capital investment subsidy.
Can you read it from the top?
Yes, please. झारखंड औद्योगिक नीति की कंडिका 29.11 में मेगा औद्योगिक इकाई के लिए विशेष पैकेज स्वीकृत किए जाने का प्रावधान किया गया है. इस मेगा प्रक्षेत्र में उन औद्योगिक इकाइयों को रखा गया है जिनमें पूंजी निवेश 50 करोड़ से ज़्यादा हो. झारखंड औद्योगिक नीति 2001 की कंडिका 22 में ऐसी औद्योगिक इकाइयां जो कि निर्धारित मापदंड के अनुसार विस्तार स्वयं की में की जाती है, उन्हें भी ये my lords फॉर एक्सपेंशन वगैरह के लिए है. झारखंड औद्योगिक नीति में किए गए प्रावधानों के आलोक में मेगा इकाइयों को विशेष पैकेज देने हेतु स्पष्ट एवं पारदर्शी मापदंड तय किए जाते हैं जो निम्नवत हैं. उपरोक्त मेगा इकाइयों को मूलतः 3 श्रेणी में रखे जाते हैं. my lords, पहला है पूंजी निवेश प्रोत्साहन अनुदान. उसमें my lords, they have applied and we have granted them the capital investment subsidy. There is no dispute, 5 point some crores, my lords. Then, my lords, the rest is for, my lords, not applicable to the petitioner, my lords. जो existing units था and for expansion and diversification वगैरह के लिए था. Then, my lords, may kindly come to page number 44, my lords. So there were 2 types of subsidies, my lords. One was capital investment subsidy, which we were granting to all mega industries, and then there was this anya anudan, my lords. Page number 44, last paragraph, my lords, before the signature of the Sachiv, my lords. Yes, my lords. Anya anudan, पूंजी निवेश प्रोत्साहन अनुदान जिसकी चर्चा ऊपर में की गई है कि अतिरिक्त औद्योगिक नीति 2001 के अंतर्गत ब्याज अनुदान प्रोत्साहन, my lords, 29.5 for which he is yes, my lords, बाकी दोनों भी है 29.6 एंड 29.9 नेगोशिएशन के उपरांत मान्य किया जा सकेगा। अतः उपयुक्त मार्गदर्शन के आलोक में ही औद्योगिक नीति 2001 के अंतर्गत मेगा औद्योगिक इकाइयों से प्राप्त प्रस्ताव पर अपेक्षित कार्रवाई की जाएगी। आवश्यकता अनुसार इसे कार्यान्वित करने हेतु नियमावली में तैयार की जाएगी। So my lords, what I am submitting but before my lords is that he has accepted this special package. He is getting a part of the benefits from this package which he could not have got under the general clauses, my lords. And now when the second part is concerned, my lords, he says that since there is no negotiation, whoever may be the responsible for that, I come under the general. And he has not said anything. He has not claimed regarding interest subsidy, my lords. So, my lords.
No, it is a specific case as recorded yesterday that he is not claiming under 28, 25.11. That he has not claimed.
My lords, so he
that
can
is a
do
specific
hot and cold,
case.
my lords,
That's
at
right.
the same time, my lords.
I guess it.
And my lords, the rules which my lords wanted to see, my lords. Then this, my lords, the next, the rules regarding the incentive rules, my lords.
Page 48.
Yes, my lords. Relevant is, my lords, at page number 54, fiscal incentives. This will be decided on a case-to-case basis by the government of Jharkhand, my lords, regarding mega industries.
Page number?
54, my lords. Incentives to be provided to new industrial units or units undertaking such and such. Then, my lords, 4.1.2 fiscal incentives. This will be decided on a case-to-case basis by the government of Jharkhand. Then, my lords, the methodology or procedure for capital investment subsidy. An application for claiming capital investment subsidy under the said rules should be made in the application form prescribed for the purpose as specified in Schedule A along with the prescribed enclosures within 6 months, my lords. And then, my lords, the cassette disposal hoga, that is given, my lords. And then the application is at page number 57, my lords. And he has applied under this, my lords, and he has been granted the capital subsidy, investment subsidy as per the special package for mega industries. So, my lords, this is the only submission, my lords, regarding my lord's query yesterday.
The learned counsel appearing on behalf of the respondent has submitted that the provision of incentive under clause 29.11 is a special provision, and the petitioner has availed the capital investment subsidy under the special provision. The petitioner, being a mega industry, was not entitled to claim capital subsidy under the scheme provided under section 29.3, which was for the purposes of giving capital investment incentive to small and medium scale industries. The petitioner, having chosen to be treated and having made application under 29.11, cannot be permitted to choose best of both the schemes. She has submitted that there is no overlap in the scheme under in a regular scheme and that of special scheme. She has further submitted that she has referred to clause 29.3 at page 28 of the paper book submitted by the petitioner. Page number 30, which clause 29.11. page 42. To show that the petitioner was granted capital investment subsidy and was treated as a mega unit under clause 29.11. And page 44 to show that for the purposes of other incentive to be granted under section 29.5 and 29.6, 29.5, 29.6 and 29.9. Decision was to be taken on negotiation. She has submitted that since admittedly the negotiation were not held, therefore the petitioner cannot be permitted to resort to section 29.5 to claim interest subsidy, as the petitioner is covered by the scheme special scheme provided under section 29.1. She has also referred to the notification dated 2nd of August 2005, which notifies the routes, namely Jharkhand Mega Project Incentive Routes 2005, and submits that it is under this rule the petitioner has claimed the benefit under 29.11 and he is governed by this rules. That is all. What do you have to say to this?
Yes. Now, Her Ladyship will kindly take the industrial policy first. Clause 29. Fiscal incentives, Her Ladyship. 29.1 is the general objective, which is also important when I refer to the judgment of Brahmaputra Metallics.
You have to refer to those judgments, right?
Yes, I will show that. All the three judgments I will show. 29.1, my lord, says there is a dire need for the lost opportunities and for industrialization for the state. Now, Her Ladyship may kindly see 29.2. That's the sheet anchor on which the entire case rests. Types of incentives which are being offered are given below. The word is types of incentives which are being offered are given below. Such incentives shall be admissible only once to a unit which comes into commercial production during the period this policy remains effective. But these words may also be, Her Ladyship, these words may also be marked, which comes into commercial production during the period this policy remains effective. There is no distinction made here with respect to any of the categories of the industries, and I'll show from the definition clause. It only says these incentives are admissible which comes into commercial production, and such incentives are available only once to a unit. Now, my lord, 29.3 has been referred by my learned colleague. So, she has pointed out that this was only admissible to small and medium scale industry. I say that it was only admissible to small and medium scale industry, and so falling under mega unit, I might not have been entitled for this small and medium scale which was provided under 29.3. The question here is whether I am entitled under the industrial policy or not. I am not claiming any entitlement under 29.3. Now, so far as second subsidy also, if your Her Ladyship may see, captive power generating subsidy admissible to new industries in various categories of districts are as follows. Then this is a captive investment subsidy of power generating plants. I am not following in this because I have not set up a captive power generating plant. Now, Her Ladyship may see 29.5. What is the language used in this?
Yes, please.
The objective of providing this subsidy is to bring down interest cost of industry for the period an industry is most hard pressed. This subsidy is aimed to encourage industry to continuous growth rather than stagnate and contribute its share of prosperity to the state. The interest subsidy admissible to new industries shall be admissible in the following manner on the interest actually paid to the financial institution banks on loans taken by such new industry. Categories, Her Ladyship have shown A, B, C to the maximum and 100 lakhs, 2% thereof. Now Her Ladyship may even come to 29.6. Stamp duty and registration. An eligible industrial unit, irrespective of its location, will be entitled to exemption from payment of 50% of stamp duty and registration fee for registration of documents within the state relating to purchase or acquisition of land and building for setting up a new unit. Then we are concerned with 29.9 because these are the three which were overlapping. Pollution control equipment subsidy. Capital investment subsidy for installation of pollution control and monitoring equipment shall be allowed on the certificate of the State Pollution Control Board about the necessity of such installation. This incentive shall be admissible to new and existing industrial units. So, the words are completely different. 29.3 whereas restricts only to small and medium. 29.5, 29.6 and 29.9 does not restrict it only to small and medium. It provides that it will be admissible to all new industrial units, including sub-existing industrial units also. Then with this background, Her Ladyship, we read 29.11. Mega units. Special packages shall be formulated for the new projects with an investment of more than 50 crores on case-to-case basis through direct negotiation with prospective investors. So this special package read with 29.3, 29.5, 29.6 and 29.9 is definitely a reading of the purpose for which this beneficial legislation has been enacted, which I will show from the judgments, is to be read in addition. This special package is addition to the mega units which have been established by the in the state, where the state promised that we will give you some special benefits on case-to-case basis pursuant to negotiation. Now, Her Ladyship may kindly take, in my compilation, the special benefit which was given, which was provided, which has been referred by my learned colleague at page 42. The very starting of it at page 42, though English type copy is also there, but not English translation, page 45, but otherwise 42 is also quite legible. झारखंड औद्योगिक नीति के कंडिका 29.11 में मेगा औद्योगिक इकाई के लिए विशेष पैकेज स्वीकृत किए जाने का प्रावधान किया गया है। इस मेगा प्रक्षेप में उन औद्योगिक इकाइयों को रखा गया है जिसमें पूंजी निवेश 50 करोड़ से ज़्यादा हो। औद्योगिक नीति की 2001 की कंडिका 22 में ऐसी औद्योगिक इकाइयों जो निर्धारित मापदंड के अनुसार विस्तार विशाखन अनुधिकरण में की जाती है, उन्हें भी नई इकाई के सदृश प्रोत्साहन प्राप्त होने तथा ये प्रोत्साहन अतिरिक्त उपादान के आधार पर देय होगा। 22 इज दी डाइवर्सिफिकेशन क्लॉज। और झारखंड औद्योगिक नीति में लिए गए प्रावधानों के आलोक में मेगा इकाइयों को विशेष पैकेज देने हेतु स्पष्ट एवं पारदर्शी मापदंड तय किए गए हैं जो निम्नवत हैं। उपयुक्त मेगा इकाइयों को मूलतः 3 श्रेणी में रखा गया है। 3 श्रेणीज आर विथ रेस्पेक्ट टू न्यू इंडस्ट्रियल यूनिट, existing industrial units and मतलब sick industrial units, नई औद्योगिक इकाइयाँ, विद्यमान औद्योगिक इकाइयाँ and घाटे में कार्यरत विद्यमान औद्योगिक इकाइयाँ. And then मतलब as per the categories of all the three, K is new. Then next page her ladyship में see Roman 2 is K is विद्यमान and C G is page 44 कार्यरत, sorry घाटे में कार्यरत. So this decision is a follow-up notification in terms of clause 29.11. Well, the line of judgment from Suprabhat and the Tata Sponge and other line of judgments. Well, I may just give her ladyship also those line of judgments. This is a follow-up notification for giving effect to clause 29.11. But a follow-up notification cannot take away what has already been promised and given. Yes. Now, my lord, Roman 2 is Anya Anudan. Kindly see this. पूंजीगत प्रोत्साहन अनुदान जिसकी चर्चा ऊपर में की गई है कि अतिरिक्त औद्योगिक नीति 2001 के अंतर्गत ब्याज अनुदान प्रोत्साहन, मुद्राक शुल्क एवं निबंधन शुल्क की विमुक्ति, प्रदूषण नियंत्रण उपकरण अनुदान नेगोशिएशन के उपरांत मान्य किया जाएगा. उपयुक्त मार्गदर्शन के आलोक में झारखंड औद्योगिक नीति के अंतर्गत मेगा औद्योगिक इकाइयों से प्राप्त प्रस्ताव पर अपेक्षित कार्रवाई की जाएगी. आवश्यकता इसे कार्यान्वित करने हेतु नियमावली भी तैयार की जाएगी. Now they say नियमावली भी तैयार की जाएगी so far as this part is concerned. Well, I will be squarely covered by Brahmaputra Metallics when I show this. This was a follow-up notification qua capital investment subsidy. And in this follow-up notification, they themselves said that so far as the other three are concerned, we will give them on negotiation basis for which we will frame sufficient guidelines. Now, my lord, admittedly, no guidelines have been framed. Kindly see the pleadings in my writ petition. It's not that I have been deprived of it.
It's right. There is no dispute. Yesterday also there was no dispute.
Yes, no dispute.
There has been no negotiation.
Yes, no negotiation with any industry.
That's right.
And my lord, in fact, one letter I just want to show from my writ petition, Annexure 4. There was a meeting which was held under the chairmanship of the Chief Secretary. And the Chief Secretary, my lord, directed the industry department that you please frame appropriate guidelines so that the other benefits including interest subsidy, pollution control equipment subsidy and the third subsidy also can be extended to mega industrial units.
No, as per your argument yesterday, you
Yes.
were not on negotiation except.
No, I am not on negotiation.
Case was that irrespective of 29.11, you are entitled under 29.11.
So correct. So my lord, what I am
so
trying.
stick to that argument.
Yes. So now my lord.
There is no negotiation, whatever be the reason.
Yes. Once there is no negotiation, my lord, whatever be the reason. Now, my lord, under the policy of 2001, 29.5 has 3-4 eligibility criteria, my lord. One is that I should be a new industrial unit.
You
Second,
satisfy all the criteria.
I satisfy all the criteria.
There is, apparently, as till now, there is no
Dispute on the satisfaction of the criteria. So now, my lord, if
the point which ultimately boils down is
yes,
that whether you can have the benefit of both.
But benefit of both to the extent as to what is being extended to me. Yes.
That you were otherwise not entitled to have capital incentive.
So, my lord, when I would have applied, if the mega policy order would have not been issued, and if you would have applied for capital subsidy, I would have been denied that.
That's right.
By saying that you are not falling within the
That's
criteria prescribed therein.
That's right.
But the moment, my lord, I would have applied for capital investment, the interest subsidy, then, my lord, I am falling within the four corners of the exemption notification or the beneficial notification. And once I fall within the four corners of the beneficial notification, then I am entitled to the
Her
benefit.
argument is different. Her argument is that
Having availed the benefit.
These incentives come as a package.
Yes.
And there was a special package for mega unit contemplated under 29.11, which would have constituted this interest subsidy as well, would have form a part of the 29.11
Yes.
scheme. Now her contention is that there were certain negotiation with respect to one element of it.
Not negotiation, a specific order was issued. That is what I want
The
to say.
order was issued and ultimately you were granted.
Yes, so it's a follow-up notification.
Yes.
Qua in the capital subsidy, special package 29.11 says.
Even for 29, even for capital subsidy, there has to be negotiation.
But not negotiation. Once I fall within, that is why the rule also, which my learned colleague pointed out, I had annexed in my compilation to show, and in fact the line, starting line, her ladyship may see of that order which was there. It's a follow-up notification which has been issued only qua capital subsidy. At page 42, it says, Jharkhand Audyogik Niti, third paragraph.
We have read it.
So it says विशेष पैकेज देने हेतु स्पष्ट एवं पारदर्शी मापदंड तय किए गए हैं जो निम्नवत हैं. So they are determining a transparent process by which capital investment subsidy is being extended, and that has been extended to all units on the basis of the rules which have been consequently framed, that you have to make an application in terms of the rule. We made an application, we got the subsidy. Now qua the interest subsidy is concerned, they did not issue up any follow-up notification in respect of special package is concerned. So now my lord, I am putting a question to myself, that in absence of any follow-up notification being put up for the interest subsidy, whether I can be denied the original benefit which has been there in the policy itself. And this requires, my lord, the question of interpretation. What is the interpretation of the policy as such? Whether by extending one benefit to me under the policy which contemplated altogether 9 benefits, can I be deprived of all the other 8 benefits? Only because one benefit has been extended, though I specifically fall in the words and the 4 corners of the policy. This policy doesn't say, the follow-up order doesn't say, that if you avail any of the benefits here, then you are not entitled for the benefit of other benefits under this follow-up order. In fact, that is why, my lord, I was repeatedly relying upon clause 29.2, because it says these are the 9 incentives, and out of the 9 incentives, you cannot take any of the incentive twice. Had it been said that in 29.2 that you have taken any one incentive under the mega policy, you are not entitled for 29.5, that would have been a complete different issue.
No exclusion as such.
No exclusion. Only exclusion is that is why, my lord, 29. Her ladyship kindly see 29.5 once again. It only says exclusion to the extent of these 9 incentives only once to a unit.
That's all.
It has not excluded that anything taken in mega, then you can't take under the policy of 2011. So, my lord, an inaction by the administrative authorities, qua negotiation, or their lethargy of not entering into a negotiation with me, or for that matter any other industrial unit, can that deprive an industrial unit what has already been promised and what I am falling within the 4 corners of the promise extended? That's the short point, my lord. Whether that is in the nature of an additional incentive which was promised and not extended, so whether I lose my original incentive also or not. And even in her ladyship, even in the impugn orders, they computed my subsidy amounts in terms of clause 29.5 and then only rejected it by saying that there was no negotiation. And it's not a case that I have applied not within the stipulated time as per 29.5 regulations.
You made an application under which rule?
The 29.5 rules, 2001 rules. Kindly see my application.
That is the policy, under the policy.
Under the original policy, read with the rules under the original policy. There are 2 rules.
Okay. Where is the other one?
Well, that is called Jharkhand Industrial Policy Rules 2001. It-
Where is that? Jharkhand Industrial Policy Rules.
Yes.
May I just clarify on that?
Just quickly. I think you just forward it to us.
Yes,
We'll
I'll
take up-
I'll give
no,
that.
No, we'll read it right now. कितना बड़ा है अभी?
नहीं एक वॉल्यूम बुक टाइप का ही है.
Let me capture your argument by that time. The learned counsel for the petitioner in response has submitted that under 29.3, the petitioner was not entitled for capital investment incentive, as the same was admissible to small and medium scale industries. But he has not been granted the benefit, but he never claimed the benefit under under clause 29.3. Rather, he was granted under 29.11. He has further submitted that no such limitation has been prescribed with respect to interest subsidy under 29.5. It is only the maximum limit of benefit which has been prescribed, irrespective of the fact as to whether the unit falls under small and medium scale or is a mega unit. He has thereafter referred to clause 29.2 and has submitted that it is the incentive under various heads under 29.2 is available to all the industrial units which come into commercial production during the period when the industrial policy was effective, and there is no exclusion with respect to mega units. He has also submitted that exclusion having not been made in specific clauses of the policy, that is 29.2 and 29.5, such exclusion cannot be read into these provisions merely because the petitioner has been granted the benefit of capital investment incentive under the clause 29.11. He has further submitted that the order issued by the industry department as contained in page number 42 of the paper book gives a formula for the purposes of grant of capital investment subsidy, but no such formula has been prescribed, and the remaining portion of the policy, remaining portion of benefit under the policy, that is under clause 29.5, 29.6 and 29.9 is left for negotiation. He has submitted that the policy was framed by the state government and no follow-up notification was issued in connection with grant of benefit under the policy in terms of clause 29.5, and no follow-up rules were framed for such purpose, and therefore the petitioner cannot be deprived of the benefit of the policy merely because the state has not acted upon in terms of the policy by framing rules and issuing notifications. He has relied upon the judgment passed by the Honorable Supreme Court in the case of Suprabhat Steel reported in bracket 1998, volume 7.
1995 volume 3 SCC. But I'll just give that.
1995 volume 3 SCC, page 7.
याद नहीं exact page याद नहीं
21.
And there is one more judgment on the same line, Tata Sponge Limited versus State of Orissa. 2000 Tata Sponge is 2007.
He has also, and similar view has been taken by the Honorable Supreme Court in the case of Tata Sponge
Iron Limited.
Iron Limited.
State of Orissa and others versus Tata Sponge Iron Limited.
इसको ठीक से लिखिए. State of Odisha and others versus Tata Sponge Iron Limited reported in
2007.
2007.
8 SCC.
8 SCC.
189.
189. The learned counsel has further submitted that the notification dated 2nd of August 2005 as contained in page 48 of the paper book has given the incentives for Jharkhand mega project is known as Jharkhand mega project incentive rules, and the application for claiming capital investment subsidy by mega projects has been is a part of such rule, but no application was prescribed under the said rule so far as other incentives are concerned. Therefore, the petitioner had applied under the 2001 rules, namely Jharkhand Industrial Policy Rules 2001, to avail the benefit under
2003, Jharkhand Industrial Policy 2003
rules to claim under clause 29.5 of the industrial policy. He has also submitted that
my colleague has just given me 4.3 is that rules.
He has referred to clause 4.3 of the said rules. A copy of the rules has been produced before this court.
Sood Anudan is clause 4.3. It was notified by, last page is notified by memo number so and so.
He submits that the said rules were notified by memo number 968 dated 26/3/2003.
Her ladyship, the next page, the form number is given, प्रपत्र संख्या 3. प्रक्रिया जो है, ग में प्रक्रिया जो है.
He submits that not only the rules were framed, but the procedure to be followed for the purposes of grant of interest subsidy was also provided. He has also submitted that the interest subsidy in terms of clause 29.3 was also quantified by the respondents, but was denied solely on the ground that there was no negotiation.
That Suprabhat Steel judgment is State of Bihar versus Suprabhat Steel, 1999, 1 SCC, page 31.
1999, 1 SCC page
31.
1995.
9.
Oh sorry. 1999 इसको ठीक से लिख लीजिए भाई, फिर खोजना पड़ेगा. 1 SCC, page number 35.
39.
39.
So, I'm sorry, 31. हमने
Page 31. ठीक है? State of Bihar versus Suprabhat.
Now, her ladyship may kindly see my pleadings in the writ petition for a moment on this aspect.
You can just give me the paragraph number.
Paragraphs 20, 21, 22. $28. 30, where I have taken the promissory estoppel and legitimate expectation also. And 33, my lord, I have taken that the said action becomes violative of Article 14.
The learned counsel has relied upon his pleadings in the petition as being WPC number 3423 of 2015 contained in paragraph 20 to 22, 28, 30 and 33, and has submitted that similar statements has been made in the other connected petitions which relate to different financial years. Submits that all the sum of claim with regard to all the financial year सब मिला के 1 करोड़
नहीं, 1 करोड़ 1 साल.
For each year he is claiming rupees 1 crore, which is the maximum permissible incentive for interest expense. Are we judgments based?
Yes. With respect to purposive
Yes.
yes,
The learned counsel has also reiterated his submissions which were made yesterday. Right? Number 10. Which judgment are you referring to?
3 judgments, my lord. Postal paper, Mother Superior on the point of how and notification which
I am
is
on the first page of your compilation. For each judgment,
Yes.
first you refer the paragraph
Yes,
number,
yes.
then we will go to
Yes. Postal paper paragraphs are 1, 2, 3,
1, 2, 3,
10,
10,
11,
11,
15,
15,
23,
23,
and 24.
24. This is on which point?
This is on the point of purposive interpretation to achieve the purpose of the beneficial notification, even in respect of tax exemption notifications, where the interpretation is strict, but even then it has to be given, the object has to be achieved.
Para
Then-
number 5.
Yes. Then second judgment is 2021 5 SCC 602. In this the paragraphs are 1, 4, 11, 13, 14, 15, 19, 26, 27, 28. And third judgment is allowed on the promise being extended by the state. This
Just a
judgment,
moment. The second judgment is on which point?
same point, my lord, purposive interpretation.
Purpose.
Yes, purposive interpretation, and the object is sought to be achieved, and interpretation is to be in line with the object sought to be
That's
achieved.
Para number, next judgment. Para
Next
number-
judgment is 2023 10 is last judgment in the 10 SCC 634, which says that the state authorities cannot act as if they are solemn doles extending the benefit and denying it by their inaction. This is from our Honorable High Court itself, Her Ladyship. In this, the paragraphs start from 20, 23, 30, 32, 36, 38, then 48, 49, 50. In fact, my lord, in this case, the Honorable Supreme Court has discussed the origin of promissory estoppel, origin of legitimate expectation, held that though the words, both the doctrines are almost used as interchangeably, even the Honorable Supreme Court has in several cases used those doctrines as interchangeably, but it has been held that promissory estoppel is only a shield, whereas legitimate expectation is a sword or can be a cause of action on the fairness of the state action. And if the action of the state is unfair, the legitimate expectation of a private individual would entail a public interest, and its action, the state action, would be deemed to be violative of Article 14. So deliberately, my lord, had given, her ladyship have given certain paragraphs so that this distinction which has been dealt with is there. But it has been said that both the principles apply, one as a shield, another as a sword, or in other words, as a invocation of the cause of action. So I can place the judge some.
The learned counsel has relied upon following judgments. 1. Postal Paper Limited versus Commission of Central Excise Visakhapatnam, reported in bracket 2015, bracket close 10 SCC 664, para 1, 2, 3, 10, 11, 15, 23 and 24. लिखा हुआ है first page में, कोई confusion में मत रहिए. To submit that, the policy is to be interpreted in a purposive construction of the policy is to be given by this court. Such interpretation has been extended even for interpretation of tax exemption notifications. Yes, also on the same point, the further judgment is Government of Kerala and another versus Mother Superior Adoration Convent, reported in bracket 2021, bracket close 5 SCC 602, para 1, 4, 11, 13, 14, 15, 19, 26, 27 and 20. The learned counsel has further relied upon the judgment of State of Jharkhand and others versus Brahmaputra Metallics Limited, Ranchi, reported in bracket 2023, bracket close 10 SCC 634, para 20, 23, 30, 32, 36, 38, 48, 49 and 50, to submit that state cannot blow hot and cold at the same time. Once by extending certain benefit through the policy and thereby denying the benefit by their inaction. He has also submitted that this judgment has elaborately dealt with the concept of promissory estoppel and legitimate expectation, and has held that two principles operate in different fields, and so far as promissory estoppel is concerned, the same is essentially a shield against the action of the other side, and so far as the legitimate expectation is concerned, the same itself can be a cause of action, meaning thereby it can be a sword. And once such legitimate expectation is established, even in a case of private action against the respondent, the same assumes the status of public interest and could be enforced through a court of law.
So, ladyship wants, I can read some paragraphs or I can just leave it.
Just leave it. We have 10 minutes.
I wanted to point out something.
Yes. Last, whatever you want to summarize,
yes.
you can respond to, because he has expanded his argument to some extent in response, so you can respond.
That's page number 28 of the compilation.
20. Yes.
Well, it's 29.2, my lords. My lords, my submission is, my lords, these are just bullet points, my lords. And for all these incentives, my lords, the details are given below, my lords. If it was framed as 29.2.1, 29.2.2, this problem would not have arisen, my lords. So these are just like capital investment incentive, my lords. Then capital investment incentive, who will be admissible, to whom it will be admissible, to what extent. Then 29.4, my lords, capital power generating subsidy, to whom it will be applicable. Then interest subsidy, my lords. So all these points, my lords, till 9, incentive for quality certification, which, my lords, we find at page number 30, my lords.
Yes.
Incentive for quality certification. So, my lords,
these are just the bullet points which we are allowing to the industrial units, my lords, and the details and the specifications regarding each of them, my lords, are enumerated there under, my lords. And after that, my lords, the mega units come, my lords. So, my lords, this is one part that the petitioner was alleging that he is bereft of availing the other benefits, my lords. So, my submission is other than 29.5 and two others, my lords, 29.6 and 29.9, he is eligible for the others, my lords. He, these three are under the Anya Anudan जो हम लोग देंगे regarding the mega scheme.
For other two, he is entitled.
Otherwise, if he is entitled, my lords,
then he has no grievance.
He has no grievance, and
he has not applied, so
he has not applied. If he would have applied, he was eligible, my lords, because those do not come under Anya Anudan, my lords, which is for a special package to the mega units, my lords. And just one more thing, my lords, page number 44, my lords. My lords, they are claiming that it is our inaction that they have not got the benefits, my lords. My lords, एक लाइन बस दिखाएंगे, my lords, लास्ट लाइन. अतः उपयुक्त मार्गदर्शन के आलोक में ही औद्योगिक नीति 2001 के अंतर्गत मेगा औद्योगिक इकाइयों से प्राप्त प्रस्ताव पर उपेक्षित कार्रवाई की जाएगी और आवश्यकता अनुसार इसे नियमावली भी तैयार की जाएगी. तो नियमावली, my lords, हम लोग तैयार कर लिए हैं, which my learned friend has referred also, my lords, page number 48. My lords, the same notification, my lords. व्यापांक 1885 दिनांक 10/6/2003 जो ये कह रहे हैं कि my lords, this is just a follow-up action, my lords. This is my sample submission is, my lords. This is an adesh, my lords, which has culminated into rules, my lords. My lords, page number 48 में, my lords, may kindly see, my lords.
Yes, we have seen that.
Yes, my lords. उसमें after this 1885 10/6/2003, my lords, these rules have been framed to grant the benefits to the mega units, my lords. And regarding the other benefits, my lords, we have invited them to give their prastav, my lords. And my lords, negotiation is a vague term, my lords. It can be in their favor, it can be in our favor, it can turn it to a nullity, it cannot be applicable, my lords. This we have introduced, my lords, because we had to give a tailor-made scheme to each mega unit, my lords, which we have said in our counter affidavit also, my lords. If we had to give them general benefits, my lords, and equal benefits, then we would have not introduced this project, my lords, this scheme, my lords. So it is for the benefit of the mega units that we have introduced this, and my lords, not a chit of paper is in the writ petition that they have asked for any negotiation or they have brought in any prastav saying कि हमको negotiation के लिए हम आ रहे हैं, मेरा ये सब अनुदान को देखा जाए, my lords. So my lords, it cannot be said that it is our inaction that they are not getting the benefit of these incentives, my lords. And regarding promissory estoppel, my lords,
let me just record what you have. I'll come to your promissory estoppel. See, I'm in a habit of recording submissions side by side to ensure that I don't miss any point. The Learned Counsel for the State has referred to clause 29.2 to submit that it is just an enlistment of the benefits, and the entitlement with basic details have been mentioned in paragraph 29.3 onwards, and mega unit has itself been defined under clause 29.11. She has submitted that no incentive can be extended to the petitioner merely by referring to 29.2 unless the petitioner satisfies the condition as per the notification itself. Particularly clause 29.11 and the scheme framed thereunder. She has further submitted that as per the notification dated 10/6/2003 as contained in page 42, it was a follow-up notification to give effect to the clause 29.11 and under clause Roman 2 thereof, it has been clearly stipulated that the application to be filed by the industry is to be negotiated in terms of the notification dated 10/6/2003, and for that purpose the petitioner was supposed to file application which could be subject matter of negotiation. And once the matter is to be decided through negotiation, there was no requirement of giving strict guidelines, and it was only when the proposal would have come, it could have been negotiated. She has submitted that there is no averment in the entire petition that the petitioner ever filed any application for grant of incentive which could have been a matter of negotiation. She has submitted that in view of the aforesaid, she has submitted that pursuant to the notification dated 10/6/2003, the required rules were also framed and notified on 9th of August 2005 as contained in page 48 of the compilation. She has submitted that it is not a case of inaction on the part of the state, rather it is a case of inaction on the part of the petitioner in not submitting any claim for interest subsidy under the aforesaid notification dated 10/6/2003 read with the aforesaid rules of 2000. How to change? To chuta? A promissory estoppel.
Yes, Manoj.
Better
Regarding
come-
promissory estoppel. Manoj, what I could understand, Manoj, they had to alter their position as per the promise by the state, Manoj, they have altered their position, like they have got a new industry, Manoj, and we have fulfilled all the promise, Manoj, regarding the capital investment subsidy, Manoj, which we were granting to the mega units, Manoj, and for the rest incentives, Manoj, the negotiation had to be done, Manoj, which never took place. So, Manoj, doctrine of promissory estoppel does not apply in this case. So all the judgments, Manoj,
with
are
respect
relevant on case
to
to
with
case.
respect to the principle of promissory estoppel / legitimate execution. The learned counsel for the state has submitted that it is not a case where the petitioner has not availed of any benefit pursuant to the promise extended by the state, inasmuch as the petitioner has already availed the benefit of capital investment subsidy pursuant to the industrial policy 2000. She submits that the grievance of the petitioner is that petitioner has been able to explain to avail only part benefit under the scheme. The learned counsel submits that in such circumstances the principle of promissory estoppel / legitimate expectation cannot come into operation, and this is without prejudice to her submission that the complete inaction is on the part of the petitioner and not on the part of the state. That's all. Okay? अब ऑर्डर रिजर्व करने
नहीं हम एक मिनट क्योंकि ये आप मेरे को बोले थे कि नेगोशिएशन वाले को नहीं दिखाने का जरूरत है, तो आई डिड नॉट शो द पैराग्राफ.
नहीं, that was your submission.
नहीं,
Promissory estoppel.
हम तो कह ही रहे कि she is saying that I did not enter into any negotiation. That is why it is my fault. This is the argument. Kindly come to Annexure 4, page 48. Date of my commercial production is 8/8/2018.
2018.
8/8/2008. And kindly her ladyship may see Annexure 4, page 48. This is the decision of the government on 27/9/2008. This decision says that the industry department will call individual mega units for the purposes of negotiation and frame up guideline as to how negotiations will be entered into for extending the other benefits which are there. Pursuant to that, my statements made in paragraphs 19 onwards, 18, 19, 20.
Yesterday you had given up this.
No, I am only answering what my colleague had answered, had tried to allege, that it was my fault that I did not enter into a negotiation. Whereas it is my case that the state government did not enter into any negotiation with any party.
No,
including the
when
petitioner.
did you make your application?
Yes, that's what I'm trying to say. Kindly see annexure 4 for a
No,
moment.
you show is from the
Yes,
pleading.
kindly see annexure
We
4.
will not see from the annexure.
No.
You have to show from the pleading as to after coming into force of commercial production, when did you approach them for the purposes of negotiation?
That's what, in order to see that, kindly just have annexure 4, page 48 for a moment.
Annexure 4 will not decide it. You tell us.
It's
from
a
your
document
pleading.
of the state government.
We will not see like this.
Then,
Because, you see, there is a problem by referring to the annexure, because if you, they need to respond only to your pleadings. They do not
So
respond to
I
annexure.
show my pleadings, para 18 onwards, kindly see from 17 onwards.
Yes.
That specific pleading which is there. In context of the, in fact I will state, my lord, from para 16, 3 lines. However, from para 16, third line, however, it is categorically stated herein that under the special package frame for mega industrial unit, although it was stated therein that other fiscal incentives provided under the industrial policy, including interest subsidy, under clause 29.5 would be payable to industrial unit pursuant to negotiation. But no such exercise whatsoever was undertaken by the state regarding negotiation for grant of interest subsidy to mega industrial unit. In context of the above, it is humbly stated and submitted that a meeting was held under the chairmanship of the Chief Secretary Jharkhand as far back on 17/9/2008, proceedings of which was communicated to respondent number 2, the concerned department by memo number so and so, wherein it was decided with respect to other subsidies admissible under Jharkhand industrial policy, including interest subsidy, the administrative department shall frame appropriate proposal and take approval of the state government in that regard. But in spite of such direction issued by the screening committee headed by the chief secretary, no proposal was framed by the industry department entering into negotiation with new industrial units having status of mega industrial unit for grant of benefit of interest subsidy. Then, my lord, kindly see para 18. That at this stage it is reiterated herein that although under the specific pleadings, that's what I want to show. And then under those circumstances when they did not held any, well, I'll just read 18 because there is a repetition again 18. That at this stage it is reiterated herein that although under the special mega package it was provided therein that benefit of other subsidies available to new industrial units under the Jharkhand industrial policy would also be extended to mega industrial units. Pursuant to negotiation, no such negotiation process whatsoever was initiated by the state of Jharkhand with any industry. Further, in spite of direction given by the Chief Secretary to Industry Department for framing appropriate proposal for entering into negotiation with mega industrial unit for grant of interest subsidy and other subsidies as available under the industrial policy, but no such proposal was framed and in turn no negotiation was ever initiated by Industry Department or by state of Jharkhand. Then, keeping in view that no negotiation whatsoever was held with mega industries in respect to grant of special package over and above the incentives provided under the Jharkhand, the petitioner industrial unit was entitled to claim interest subsidy under the policy. Then, my lord, I say that it is a special package. Then I applied, which I am saying that para 22 I applied there. So, my lord, and these paragraphs in the counter affidavit has not been denied. So, this is where, my lord, I want to invoke, my lord, the judgment of Brahmaputra Metallics, and my lord, even in reply to the partial benefit which has been extended. In the case of Brahmaputra Metallics also what had happened, Her Ladyship, that there was a follow-up notification which was to be issued. There was delay in issuance of the follow-up notification, due to which partial benefits were denied to the industry and partial benefits were extended. Now, we had challenged the notification by saying that the delay in the notification cannot deny me the partial benefit which has already been extended in the policy. This Honorable Writ Court allowed it by saying that this delay and inaction on the part of the state cannot deny the benefit. The same has been upheld by the Honorable Supreme Court on the same lines. My lord, and this I am not repeating judgment because the judgments are there. Kalyanpur, my lord, Her Ladyship is aware about the judgment of Kalyanpur, the famous judgment from state of Bihar. State, then Modi Padamla judgment. State, then the Tata Cummins judgment. Her Ladyship had appeared in that matter. All these judgments. नहीं 2006 4 SCC.
हम तो भूल भी गए.
नहीं मतलब भूल जाएंगे लेकिन हम लोग तो देखते हैं ना वो जो हाई कोर्ट का जजमेंट है सुप्रीम कोर्ट का जजमेंट है. Her Ladyship had appeared in that Tata Cummins.
Binding on me.
Huh?
I have appeared in the case.
No, not binding. The ratio is of course binding because it's Supreme Court judgment.
Ratio is binding, not the fact that I have appeared.
Of course not. that, well, we feel pride. Well, I had appeared in that Brahmaputra metallic judgment which has been upheld by the Supreme Court. So I feel proud that I have appeared which has been upheld by a civil appeal. So,
and very detailed judgment.
And very detailed judgment. So this honorable court judgment has been upheld, and that too in a span of not less than 30 days. Well, the first day when the notice was issued by the state, we were on caveat. We were asked to file our written submissions within 10 days. And the judgment came within 30 days. If her ladyship would see, not even 30 or 40 days from the original judgment. So, my lord, my submission is only to the effect that an inaction on the part of the state with respect to the extension of the benefit cannot deny me the benefit which is already promised if I otherwise fall within the contours of that incentive. And so, my lord, it's not it's becoming a repetition, so I will not repeat.
2003, my lord, special package was granted to them, my lords. They waited, no negotiation took place, and my lord, they are now relying on the Annexure 4, which is the minutes of meeting between the state departments, my lords. From 2003 to 2008, my lords, they have not done anything, my lords.
Don't fight. There will be a judgment.
And my lords, एक चीज और बताना चाह रहे हैं.
मेरा 8 अगस्त को production है 2008.
Impugned order है, my lords. They say that no negotiation has taken effect with other, my lords. My lords, specifically only 4 industrial units have been said that because of non-negotiation, my lords, सूद अनुदान नहीं दिया जाएगा, my lords. So, my lords, the rest the negotiation must have happened, and then they have got the interest subsidy.
Again, beyond records.
The learned counsel for the petitioner has also referred to paragraph 16 to 18 and para 16 to 31 to submit that the fault was completely on the part of the state in not acting as per the scheme and not undertaking negotiation with the parties. And therefore the argument of the state that the petitioner was at fault is not correct. The counsel for the respondent has also submitted that as per the impugned order, case of only 4 persons were rejected.
Yes,
and so far as the other persons are concerned, general statement has been made in the petition. Right? इतना ही तो बोलेंगे. Concluded?
But then my counter may kindly be seen, my lords, when at the time of. My lords, because we have taken a point that before the start of production, my lords, commencement of the project, they had to come for negotiation, my lords. This is a specific plea in the taken in the counter. Amended writ petition, my lords.
Yes, amended writ petition. And then you have filed a counter to the amended writ petition?
Yes.
The learned counsel for the state has referred to paragraph, बताइए paragraph.
My lords, para 12, my lords.
Para 12 of the counter affidavit.
Yes, my lords, para 16.
Yes. Para 12, 16,
17,
12, 16, 17,
18,
18,
and my lords, 19.
19. The learned counsel for the state has referred to paragraph 12, 16, 17, 18 and 19 of the counter affidavit to the amended writ petition. Counter affidavit has been filed on 19/9/2024 and has submitted that the petitioner that the negotiation was to be undertaken
prior to commencement of investment.
Prior to commencement of investment.
Yes.
During the course of argument, it is not in dispute that the date of production of the petitioner is 8/8/2008. 8/8/2008. So the argument is concluded.
But this prior is not in the clause of the policy, neither in the special package. Her ladyship may just see that. In 2012 policy, there is a condition of prior negotiation.
हम लोग को तो होमवर्क आप लोगों ने दे दिया है.
आप लोग को भी बहुत होमवर्क है उधर छुट्टी में.
आप लोग को कहाँ होमवर्क है?
बहुत होमवर्क रहता है छुट्टी में. I'll give those judgments Suprabhat and Tata Sponge in the course of the day.
हाँ
Right?
खाली citation दे दीजिए. Citation तो
तो
दे
दे
दिए.
दिया.
अगर है तो print दे
हम
दीजिए.
अभी दिलवा देंगे. और वो prior negotiation पे भी अगर बोलेंगे तो there are several judgments which says prior negotiation does not mean it is cannot be done post facto.
इसका भी judgment का date दीजिए. हम date दे दें. Post for judgment on nineteenth of December. For judgment.
From daily list, item 7 WPC 646 of 2019.
Present proposal filed for the cancellation of acquisition of land by state government for Adani Power in Godda. And on 13th of February 2020, direction was made to the respondents to file counter affidavit, but it has not been filed.
What is the ground?
The first ground is that the project is not for public purpose. The company is private. The produced electricity will be transmitted, sold to Bangladesh. The coal is being used from foreign countries. In power purchase agreement, there was a clause that if any power plant is being set up in the state,
Just a moment. Did you comply with the order dated 10/12/2019? Did you comply with the order dated 10/12/2019? You are unaware?
because some other advocate appeared.
ऐसे रिकॉर्ड में आप इस तरह से बोलेंगे अनअवेयर तो बहुत ज़्यादा ही मुश्किल है.
I approve.
Nothing has been filed now. We have to type out.
There was a specific order, though in paragraph 3 of the petition it has been stated by the petitioner that all the petitioners come under the category of affected person as defined under right to fair compensation and transparency in land acquisition, rehabilitation and resettlement act 2013. Yet no detail or description of land of the petitioner for which the acquisition proceeding was initiated has been given. Counsel for the petitioners prays for adjournment to bring on record the same details by supplement. कहाँ है? ऑर्डर बिना कंप्लाई किए आप क्या सोचते हैं? ऐसे ऑर्डर हो जाएगा? ना सर नहीं ना हो सकेगा. ठीक है ना? You are into a very serious case. So seriousness should reflect from your conduct. आपका वकालतनामा है?
Yes.
क्या नाम है?
Mohammed Shahada.
Sorry?
Mohammed Shahada Ansari.
मोहम्मद शाह. WPC number 646 of 2019. The learned counsel for the petitioner Mohammed Sadab Ansari has submitted that he has entered appearance in this case by filing wakalatnama. When did you file wakalatnama?
Actually, I have filed this case. Meantime, Mr. Sonal Tiwari was appearing.
How?
He has also wakalatnama in this case.
So you are there in the record right from beginning. तो अभी नया कहानी कैसे सुना? कुछ भी चलेगा क्या? Counsel for the petitioner, Mr. Sardar Ansari, has submitted that in spite of order dated 13/2/2020, no counter affidavit has been filed by the respondents. However, during the course of hearing, it appears that the order dated 10/12/2019 has not been complied by the petitioner, and thereafter, when the case was taken up on 13/2020, there is no mention regarding compliance of order dated 10/12/2019, and it appears that the said order was not brought to the notice of the concerned court, and counter affidavit was directed to be filed. Order dated 10/12/2019 and 13/2/2020 are quoted as under. At this, the counsel for the petitioner prays for time to comply the order dated 10/12/2019. Post this case on 12th of November to ensure compliance of the said order. The affidavit be filed by 11th of November.
Okay.
In supplementary list.
Item 8 WPC 746 of 2019.
Yes, petitioner.
By the matter pertains to determination hair rent.
Determination of
Hair rent.
fair rent. All the courts have decided against you. So, what is the perversity in the order passed?
Actually, under section 8 of the Building Act 1982, the
1982. This is under old act.
Yeah, it was decided under this act.
Under which act it has been decided? 82 Act.
Yes.
And
Matter is quite
Jharkhand
old.
JDCJ Act.
Matter is quite of old matters. They should have decided this matter under 2000 Act, but they have decided in 1982. Or moreover, they have enhanced the rent up to 500%. There is
When was
section
the
8.
case filed?
This
It
case
was filed under the after coming into force of the new act.
Yes.
Or it was filed prior to that.
The date of
First
controller
application.
was decided the matter on
Decided नहीं application का file.
we have filed the first.
When was the first application filed?
7th of January 2006, the order was passed.
आपसे क्या पूछ रहे हैं, आप क्या जवाब दे रहे हैं? ओरिजिनल एप्लीकेशन कब फाइल हुआ? In spite of repeated queries made by this court, the counsel for the petitioner is not in a position to inform this court as to when the original application regarding fixation of parent है? Parent was filed before the concerned authority. the counsel for the petitioner prays for time to prepare himself in this case. Who is for the private respondent? Absent. या notice ही नहीं हुआ. Notice नहीं हुआ. बिना सुने तो notice भी नहीं करेंगे. 12 तारीख 12th November. Accordingly, this court is not inclined to issue notice today.
Item 9, the PC 2512 of 2019.
Yes, petitioner. Absent. पिछली बार भी absent थे क्या?
No, on the last occasion, Lordship has directed to file supplementary counter affidavit, and there was a direction of the petitioner to file his bond. Pursuant to last modern ladyship, supplementary counter affidavit has been filed.
You have filed the supplementary affidavit?
Yes, Your Lordship.
Where is it?
It has been filed on the ladyship 27/9/24. Para 6 of
The inquiry report was against?
Yes, Your Ladyship. Earlier, the inquiry report was against him, but on the last occasion, Lordship has said that pursuant to the inquiry report and the guidelines which petitioner has relied on, we should pay the amount. So we have perused the guidelines and the ACP report, and we have paid the admitted dues of 53 lakhs to the petitioner. Para 6 of the supplementary counter affidavit may be.
Para 6 of the supplementary counter.
Supplementary counter affidavit.
11/1/24.
27/9/24.
What is this IA for? Early hearing.
Only for earlier filed by the petitioner.
And also for filing additional documents.
Yes, Your Ladyship.
It was a contract.
Ladyship, BTP, it was a vocational training petitioner is a vocational training provider registered under the labor employment and training program. Petitioner has submitted the bills which was due to pay. So thereby in ACB inquiry was conducted. In the inquiry 44 institutional were not 44 name of the 44 institutes were selected which has not given the training, and the petitioner's name was also there. Thereby again petitioner submitted on representation, and then the representation petitioner has relied on certain guidelines. On the basis of the guidelines and the representation, we have in the supplement we have provided the admitted dues of 53 lakhs we have paid to the petitioner.
कहाँ है आप paragraph?
Paragraph 6, Your Ladyship, supplementary contract affidavit. Filed on 28/9/24.
16/9 का एक एफिडेविट है, काउंटर एफिडेविट. 6/9 का काउंटर एफिडेविट है.
Yes, इस काउंटर.
उसके बाद एक और फाइल की.
उसके बाद एक और फाइल हुई है.
एक बार में सारी चीजें नहीं फाइल कर सकते हैं आप. बार-बार ऑर्डर होता है इसमें. पैरा नंबर 6.
Para 6. That by order bearing number so and so dated is the Jharkhand Society for Skill Development Initiative script has directed to transfer the total admitted dues of 53 lakhs 21,694 to the petitioner. The order is annexed as annexure here.
WPC नंबर 2512. ये मिस्टर इनको बुलाइए भी. ब्राइट कौन थे पिटिशनर की तरफ से? बुलाइए मिस्टर अभिजीत कुमार सिंह को सेकंड हाफ में बुलाइए. उनके सामने ऑर्डर करेंगे ना कि अगर सर्वाइविंग ग्रीवेंस होगा तो अपना करेंगे सूट, उनको जो करना है. उनके एब्सेंस में ऑर्डर नहीं करना चाहते. यू हैव स्टेटेड दैट द डिस्पिटिशन हैज बिकम इनफैक्चुअस. तो एडमिनिस्ट्रेटिव आपने पेमेंट कर दिया, बाकी के लिए लड़ेंगे वो, उनको जहाँ लड़ेंगे. ये तो है.
On the last occasion, Mr. Naveen Kumar has appeared for the petition.
उनके जिसका वकालतनामा होगा उसी को ना खोजेंगे हम लोग। Yes. अभिजीत कुमार सिंह का वकालतनामा है ना, he might have been engaged as a senior. सीनियर का रिस्पॉन्सिबिलिटी थोड़ी है, जिसका वकालतनामा है उसका रिस्पॉन्सिबिलिटी।